Ladies and gentlemen, welcome to the Weekend Review. I'm your Lone Wolf Oozle, and we are here for some cases this afternoon. This is a Saturday weekend show that we do every week here on the channel, and today we've got a whole lot to watch. We're starting things off in Conot, Ohio. I think I said that right. Conot, Ohio, with Joe Giarochi, who is not in a very good mood with his very, very stupid defendant that's in front of him. Then we're moving over to Wisconsin to check in with Judge Mogan, who's got an equally dense defendant who is not going to be going home today, ladies and gentlemen. Spoiler alert. Then we're going to Kansas and over to Michigan. But right now, everything's getting started. See ya.
Okay, the court is on the record in State of Ohio versus Lucas Vickery, 24 CRB 348. City of Conneaut versus Lucas Vickery, 24 CRB 268, 24 CRB 267, 24 CRB 251, 24 CRB 213. All of these cases are set for a preliminary revocation hearing today. Probation violation complaints were filed against Mr. Vickery in all of these cases. On January 8th of 2025, warrants were issued for his arrest, and Mr. Vickery was arrested on those outstanding warrants on February 26, 2025. He is appearing at this hearing by way of video from the Conneaut City Jail. Also present is probation officer Sean Benoit, who is appearing on video. He's in the courtroom. Mr. Vickery, several probation violation complaints. They're all the same complaint, but they've been filed in each of these cases. Have you received copies of those complaints?
Yes, sir.
Okay, I'm going to read you your rights. So please pay attention to the rights I'm about to read to you. You do have a right to be informed of and to understand the nature and the elements of the complaints filed against you. You also have a right to know the potential penalties that could be imposed. In 24 CRB 348, this is where you were recently convicted on December 10th of 2024 of receiving stolen property. The probation violation complaint, and the complaints all allege that you failed to maintain contact with adult probation, failed to comply with recommended treatment through community counseling center as ordered. But anyways, if you're convicted of violating your probation in this case, I could impose up to 165 days in jail. I could extend your probation from what was originally 2 years up to a maximum 5 years, and or I could impose more restrictive community control sanctions, more restrictive than what I've already imposed. Do you understand the maximum penalties you face if convicted of violating your probation in that case?
Yes.
The next case, 24 CRB 268, you've been convicted of 2 counts of theft. If you're found to have violated your probation in that case, and those sentences were ordered to run consecutive, I could impose up to 342 days of jail, 171 days on each of those counts of theft, so a total of 342 days in jail. I could extend your probation from 2 years up to a maximum 5 years, and or I could impose more restrictive community control sanctions, more restrictive than what I've already imposed. So when I say 342 days, that would be in addition to the 165 days that you face on the previous case, receiving stolen property case. So in total, I could sentence you to up to 507 days in jail if violating your probation in both of those cases. So do you understand that?
Yes, sir.
In 24 CRB 267, you were also convicted of theft, another count of theft. If you're found to have violated your probation in that case, I could impose up to 171 days. That would, even though I originally ordered those consecutive, unfortunately for me, I cannot impose more than 540 days of jail, so that would have to be concurrent to any sentence. So that would run at the same time of the 507 days that I've indicated, the maximum time you could serve. I could extend your probation from 2 years up to a maximum 5 years, and/or I could impose more restrictive community control sanctions, more restrictive than what I've already imposed. So do you understand the consequences you face in that case?
Yes, sir.
In 24 CRB 251, you were convicted on August 15th of 2024 of criminal trespass. If you're found to have violated your community control in that case, I could impose up to 29 days in jail to run at the same time or concurrent with the other jail sentences. I could extend your 1 year of supervised probation from 1 year up to 5 years, and/or I could impose more restrictive community control sanctions. You understand the maximum potential consequences you face on that case?
Yes, sir.
Finally, in 24 CRB 213, you were convicted of littering, a first-degree misdemeanor, on September 9th, 2024. If you're found to have violated your probation in that case, I could impose up to 171 days in jail. Again, that would run concurrent or at the same time of your other jail sentences. I could extend your probation from 2 years up to a maximum 5 years, and/or I could impose more restrictive community control sanctions, more restrictive than what I've already imposed. So do you understand the maximum consequences you face on that case?
Yes, sir.
You have a right to remain silent and not to say anything during this hearing that might incriminate yourself. Any statement you make could be used against you. You also have a right to a final revocation hearing. That's another hearing. At that final revocation hearing, you would have a right to cross-examine witnesses and confront evidence presented against you. You would have a right to testify or not to testify without any negative connotation. You would have a right to subpoena witnesses to testify on your behalf. You would have a right to be proven guilty by a preponderance of the evidence. All of those are hearing rights you would have at that final revocation hearing. You also have a right to have an attorney represent and advise you in this case. And because you are facing a possible jail consequence, you do have a right to court-appointed counsel and to have a lawyer assigned to represent you only if you cannot afford one. If you do qualify for court-appointed counsel, there is a $25 application fee and a $50 cost reimbursement assessment that apply, because I believe in all of these cases you were never represented by counsel, the public defender's office in particular. You also have a right to a continuance of this preliminary revocation hearing in order to retain the services of your own attorney or to consult with your own lawyer. If you are convicted of violating the terms of your probation in any of these cases, you have a right to appeal the conviction or sentence. That must be done within 30 days of the conviction, and you would be entitled to a court-appointed attorney in the Court of Appeals if you receive a jail sentence and cannot afford a lawyer. Now, if you plead not guilty today to any of these probation violation complaints, I will set your case or cases for further proceedings after today. I'll set it for a final revocation hearing, and I will set a bond. A bond is set by the court to ensure your appearance at all future proceedings, and today you have the right to a reasonable bond. So with respect to each of these probation complaints, Mr. Vickery, you have two plea options. You can either plead guilty or not guilty. If you plead guilty, that is a complete admission by you to the complaint filed. If you plead guilty or completely admit to the complaint, the court will find you guilty, and then I will impose sentence. The second option is you can plead not guilty. If you plead not guilty, that is a denial by you to the complaint filed, and as I said earlier, if you plead not guilty, I'll set your case or cases for a final revocation hearing in the near future, and I'll set a bond. Mr. Vickery, do you have any questions whatsoever regarding the rights or the plea options I've just explained to you?
No, sir.
Okay, we're going to start with the probation violation complaint. They were all filed on January 8th, 2025. With respect to the first case, this is the receiving stolen property case in 24 CRB 348. How do you plead to the probation violation complaint in that case?
Guilty.
In 24 CRB 268, this is where you've been convicted of 2 counts of theft on September 9th, 2024. How do you plead to the probation violation complaints in those cases, or in the complaint in that case?
Guilty.
To the probation violation complaint filed against you in 24 CRB 267, this is where you were convicted of 1 count of theft on September 9th, 2024. How do you plead to the probation violation complaint in that case?
Guilty.
To the probation violation complaint filed against you in 24 CRB 251, where you were convicted of criminal trespass, a 4th-degree misdemeanor on August 15, 2024. How do you plead to the complaint filed against you in that case?
Guilty.
Finally, with respect to 24 CRB 213, where you were convicted of littering on September 9, 2024, that is a 1st-degree misdemeanor. How do you plead to the probation violation complaint filed against you in that case?
Guilty.
Do you understand, Mr. Vickery, by pleading guilty to these complaints, that you are waiving your right to a preliminary and final revocation hearing, which means you'd be waiving your right to cross-examine witnesses and to confront evidence presented against you? You'd be waiving your right to testify as well as not to testify without any negative connotation. You'd be waiving your right to subpoena witnesses. You'd be waiving your right to be proven guilty beyond a reasonable or by a preponderance of the evidence. All of those are hearing rights you'd be waiving by pleading guilty to these complaints. Are you sure you want to do that today?
Yes, sir.
You are also, by pleading guilty, waiving your right to an attorney. You do not have an attorney that is representing you or advising you at the current time. By pleading guilty, you would be waiving your right to an attorney. Is that what you want to do?
Yes, sir.
Are you currently under the influence of any drugs, alcohol, or prescription medications that might affect your thinking?
No, sir.
Are you currently on probation, parole, community control, or post-release control with any other court?
No, sir.
Has anyone made any promises to you about what your sentence will be in order to induce you to plead guilty to these complaints?
No, sir.
And are you thinking clearly and do you understand everything that's happening?
Yes, sir.
Okay, I'm going to ask the corrections officer to provide you with 5 of the separate Form 5s. So 1 for each of the cases. They're Form 5. For the record, Mr. Vickery, do you read and write English?
Yes.
Now he's going to give you 5 of these forms, 1 for each of the cases. The form says all the same thing. Basically says, I understand that I have a right to a preliminary final revocation hearing. At any hearing, I have the right to confront witnesses against me, to cross-examine witnesses, and to require the case be proven by a preponderance of the evidence. At my hearing, I could testify on my own behalf, but that I could not be compelled to do so, and that I could have witnesses testify on my behalf and have compulsory process for obtaining the presence of witnesses, that I have a right to an attorney and a right to a postponement to secure the services of an attorney, and that I am without funds to secure the service of an attorney, and the court finds this to be the fact, I have a right to have a court appoint an attorney to represent me without charge. I hereby waive these rights and submit the matter to the court. If you find those documents, all the same document, acceptable, you can sign the end date at the bottom of each of those 5 documents.
They've all been signed, sir.
Thank you. Thank you. The court finds that the defendant has executed in open court the 5 separate waiver of hearing rights and probation violation matters. Before I make a finding of guilt, Officer Benoit, would you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, officer, can you tell us, first off, your name, your position, and the nature of and the basis for these probation violation complaints?
I'm Sean Benoit, City Probation Officer. The basis of the complaints arise from him not maintaining contact with myself in my office through scheduled appointments, and he failed to comply with the treatment recommendations through community counseling. He had assessments complete while he was incarcerated the last time, had appointments scheduled that he failed to maintain, and that was about it, Your Honor.
Okay. The court finds probable cause exists for the filing of the complaints. I do find Mr. Vickery's pleas of guilty to be knowing, voluntary, and intelligent. As I said, I do accept the guilty pleas, and I will therefore find him guilty of violating his probation in each of these cases. Okay, Mr. Vickery, before I impose sentence, and you do face up to a maximum 507 days in jail, is there anything you would like to say?
No, sir.
Seriously?
Yes.
You don't have anything? You don't have anything to say, Mr. Vickery?
No, not at the moment.
I mean, this has been your mantra ever since we started seeing you, in the summer of last year. I mean, you just come into court, you admit to the complaints, you don't want an attorney, you just want me to sentence you. Do you want me just to send you to jail for 507 days? Is that what you want?
No, sir.
Well, then tell me why! Tell me why I shouldn't send you to jail for 507 days. Speak up. Defend yourself. Say something. Help me to know what is going on in that head of yours.
Sir, I would like to become a productive member of the community. I've had trouble finding employment, and I've had trouble finding housing. And I had just recently obtained a phone to make contact with Mr. Benoit. But I understand
What was that last?
I
What was
have not
that?
made contact with him.
What was that last part? I didn't hear that. I'm sorry.
I had just obtained a phone to contact Mr. Benoit.
You mean the probation officer, Mr. Benoit?
Yes.
You mean to tell me you never knew how to reach him before just recently?
Not other than to walk into the courthouse.
Well, that's a lie. You want to stick by that statement? The last time you were in jail was not too long ago, and I know Mr. Benoit met with you and he gave you his contact information. Is that correct, officer?
You
Of course.
had a card with the next appointment.
Yeah. You know where his office is. You know where the court is, right?
Yes, sir.
You ever make any attempt to come up here and to have communications with him, or do you wait for us to reach out to you?
No, I did not make any contact with him.
Okay, did you ever follow up or follow through with anything that was required of you at the Community Counseling Center after you were assessed in the jail the last time?
No, sir.
Why not?
No answer, sir.
You want to become a productive member of society, yet you don't follow through with anything. What's going on with you, Mr. Vickery? We've had this conversation before. You don't have much of a criminal history other than what's happened in the last year. So what's going on? Why all of a sudden are you doing what you're doing and you don't seem to care?
I just don't know what to say, Your Honor.
Okay, Officer Benoit, any positions?
No, Your Honor, I do believe that he does have a desire to change, and given opportunities, I would hope that he would take those opportunities if he was presented with one.
Okay, Mr. Vickery, I want to hear it from you. I want to hear it from you. And I shouldn't be begging you to tell me that you want help. You understand that?
Yes.
I mean, if you really wanted help, Mr. Vickery, you would be on your hands and knees asking me for help. But instead, you just say, well, no, I don't really have anything to say. So, I'm giving you this opportunity, Mr. Vickery, to tell me what you would like the court to do.
I would like help, sir.
What kind of help, Mr. Vickery?
Help with rehab, help with employment, help with housing.
And we've offered you help, perhaps not as intensive as what help we could provide you, but we have provided help for you in the past. Why haven't you, why should I say, or why should I be thinking that today is any different than the past? Probation officer is there to assist you, to insist, because I've ordered you in the past to obtain and maintain employment. I've ordered you in the past to get an assessment and to follow through with any recommended course of treatment. The probation officer is there to assist, to help you improve your life. So help me understand why now is different than the past times when we've offered you that assistance.
Your Honor, I don't want to spend any more time in jail. I would love to spend time with my kids, and I would love to just get back to normal. I apologize for not following through with the assessment and everything before. I will do this time.
Okay. So before this hearing, I had Officer Benoit and our bailiff meet with you. So Officer Benoit, did you happen to talk to Mr. Vickery about renewal court?
Yes, Your Honor, I did talk to Mr. Vickery about renewal court. I let him know about the program, the intensity of the program, what is expected of him, what it provides him. Mr. Vickery did accept and fill out an application for that specialty document, Your Honor.
Okay. Mr. Vickery, renewal court is an intensive supervision program. As Officer Benoit, I'm sure, has explained to you. It's intense. But if you really want to change your life, and based on what Officer Benoit has indicated, you've actually signed an application to be part of that program, there's a lot going to be required of you. Are you ready for that intensity, that very intense supervision that will come with that program to help you change your life?
Yes, sir.
You do have that application?
Yes, Your Honor.
Okay. Okay, here's what I'm going to do. He was arrested on February 26th, right?
Yes, Your Honor.
So he's entitled to 2 days jail credit. February 26th to today's date, February 28th. In 24 CRB 348, this is the receiving stolen property case. I'm imposing a jail sentence of 15 actual days in jail. So 180 days total sentence 150 days suspended. I will give him 2 days jail credit, which means he has to serve for an additional 13 days. That will give, I believe, the agencies time to conduct another assessment on him, because I'm sure they're going to need to assess him again, and for all the screenings to be done for renewal court purposes. I'm going to extend his probation for 1 year. I'm ordering him to obtain a comprehensive diagnostic assessment with the Lake Area Recovery Center. And Community Counseling Center. And to comply with any recommended course of treatment. He's to remain drug and alcohol free, and all the other conditions of his probation that are already in place will continue. I will order him to successfully participate in and complete renewal court if he's determined to be eligible. In case number 24 CRB 268, and I'll start with 268A. That's the first conviction of theft. I'll give him. This is consecutive, so I'm going to suspend all 171 days in jail in subcase A as well as subcase B, so there won't be any actual jail time. I'm extending his probation for 1 year. Comprehensive diagnostic assessment at Lark and Community Counseling Center. Successfully participate in and complete renewal court if determined eligible. And you know, I'm just going to stop right here because I'm going to keep going, but I want to just say something, Mr. Vickery. Part of that recommendation may be that you have to go into residential treatment, meaning that you're going to go to live somewhere to help assist you with your treatment. I want to make sure that I'm not the experts. They're the ones who are going to determine whether you qualify for residential treatment or not. But I want to make sure, Mr. Vickery, that you're on board with that.
Yes, sir.
Okay. 24 CRB 267. This is the conviction of theft. Again, 171 days will continue to be suspended. I'm extending his probation 2 years, or 1 year, for a total of 3 years. And if I misspoke, I want to make sure all of these probation will be extended for 1 year. Lake Area Recovery Center and Community Counseling Center assessment, comprehensive diagnostic assessment. Successfully participate in and complete renewal court if determined eligible. Now, all three of those sentences in 24 CRB 348, 24 CRB 268, and 24 CRB 267 are consecutive. And that's the most I can sentence him to. The other cases, 24 CRB 251, criminal trespass, I'm going to order the same things, but I'm suspending 29 days, but that sentence is concurrent. I'm extending his probation from 1 year up to, from originally 1 year up to 2 years, I'm extending it to 1 year. All the same conditions, comprehensive diagnostic assessment at Lark and Community Counseling Center, successfully participate in complete renewal court if deemed eligible. Same applies to littering in 24 CRB 213. 171 days will be suspended concurrent to all other sentences, extending his probation 1 year. Comprehensive diagnostic assessment at Lake Area Recovery Center and Community Counseling Center, and successfully participate in and complete renewal court if deemed eligible. So you're going to sit there for a couple weeks, Mr. Vickery, and we're going to get you assessed while you're in jail. If by chance we receive assessments and completed screenings before your 13 days, the balance of your 13 days of sentence happens, I may release you early, and especially if it's directly into a residential treatment program. So we're going to try to get those assessments scheduled as soon as possible. And then if by chance, Mr. Vickery, you are found to be eligible for renewal court, I will conduct one more hearing to welcome you into that program. And so right now it's up in the air. We don't know whether you're going to participate in or not. It all depends on those screenings. So do you understand all of that, Mr. Vickery?
Yes, sir.
You do have a right to appeal. You have a right to appeal without cost. You have a right to have counsel appointed on appeal without cost. You have a right to have documents provided you necessary to file an appeal without cost. And you have a right to have a notice of appeal timely filed on your behalf. Mr. Vickery, do you have any questions whatsoever?
No, sir.
Officer Benoit, anything?
No, Your Honor.
Okay, this matter is concluded. Thank you.
All right, I seem to have a Samsung now that was able to come in. I have Ms. Donaldson and Ms. Shaw.
Well, I don't even have things set up right. This is just embarrassing. Let me do this. So look, we're going to Judge Mogan now. Judge Mogan is in Burnett County, Wisconsin, in case anybody didn't. This is a very interesting case. If you haven't seen it, buckle up, pop some popcorn. We've got about 50 minutes to go in this one, ladies and gentlemen. It'll be interesting. Let's check it out.
Who is the Samsung? Can you hear me? Ms.
Yes, I can hear you. Can you hear me?
Okay. Yes, I can hear you now. What is your name, sir?
Mike Benjamin. I'm
Okay, I'm
Sarah's
just gonna-
significant other.
All right, I'm just going to put it in there so I know. And we are
Thank you.
only having Ms. Shaw, or which one is speaking, Ms. Shaw or
Ms. Donaldson.
Ms. Donaldson. All right. Okay. We will go on the record in the matter 23 CF 55, State of Wisconsin versus Sarah Stady. The state appears through District Attorney Kevin Schmidt in person. We have Sarah Stady in person in custody with counsel Daniel Chapman. We're set here today for a plea and sentencing. The parties have reached an agreement. Mr. Chapman, can you please recite the agreement for the record?
Judge Ms. Stady will be pleading guilty to the fifth offense OWI charged in the information. The state has agreed to recommend the presumptive minimum 18 months initial confinement, and there is no particular agreement on extended supervision. The state has agreed that Ms. Stady and I can argue for less under the benefit to the community exception under 346.65. But that is the agreement, Judge.
All righty. Okay. And Ms. Stady, that is the agreement that you've reached with the state,
Yes,
and
Your
that is
Honor.
your understanding.
Yes, Your Honor.
So I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes,
Did your attorney go over this document with you?
he did, Your Honor.
Did he go over it with you thoroughly?
Yes.
That is, did he essentially read it word for word?
Yes,
And so you understand everything completely.
yes,
Now, is that your signature on the second page?
it is, Your Honor.
If you had any questions with regards to something on this document, did you ask your attorney
Yes,
and he explained it to you?
correct.
So you're pleading guilty to one count, OWI 5th. You are 33 years old. You have 12 plus years of schooling. You can read, write, and you understand the English language. You are not receiving any mental illness or disorder, or you don't have a mental illness or disorder. And you have not had any alcohol, drugs, or medications in the last 24 hours. Is that correct?
Correct, Your Honor.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes,
Did he go over with you the mandatory minimum as well as the maximum possible penalties that you could face?
he did.
All right. Now, because you're charged with crimes, you are entitled to constitutional rights. And each of those rights is listed on this document. And I'm going to go over those rights with you because this is a mandatory prison case. And I need to make sure that you thoroughly understand those rights. Do you understand that you would have the right to a trial? You would have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have a jury trial in which 12 of your peers would need to reach a unanimous verdict to a guilty plea, and you would, or not guilty, and you would have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights that you would be giving up?
Yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
correct. Yes,
Do you understand, with regards to this matter, this OWI 5th that you are pleading guilty to, the state would have to prove on or around March 4th, 2023, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. Do you understand what the state would have to prove?
yes,
You understand that the maximum possible penalty here would be up to a $25,000 fine or up to 10 years of incarceration or both. Do you understand that?
yes,
Do you also understand that there's a mandatory minimum of incarceration? The state or the court must order a minimum of at least 18 months of incarceration. Do you understand that?
correct.
And do you understand that pursuant to, as your attorney stated, 346.65 paren 2 paren AM 5, that you could argue to the court for a lesser sentence based upon whether or not the community would be harmed and et cetera. Do you understand that?
Yes, Your Honor.
But do you understand the court does not need to follow any of that argument? You understand that?
Yes,
All right. Now, did you go over the criminal complaint with your attorney?
I believe so.
And in particular, there is a section called the probable cause section. Do you remember that?
It's been a while since we went over that.
All right. So he's showing you the criminal complaint right now, in which it does go over what happened that day and why you were charged with these crimes, all right?
Yep.
And so you see that right now.
Yes,
So now, does that refresh your recollection?
yes,
And for the most part, are those facts accurate?
yes,
Are you admitting here today that you in fact did operate a motor vehicle while under the influence of an intoxicant?
yes,
And this would be your 5th offense.
yes,
May the court use the probable cause section of the criminal complaint along with the statements made by your client to find a factual basis.
Yes, Your Honor.
Has anyone made any threats or any promises to you, Ms. Stady, for you to plead guilty to this charge?
no,
You're doing so freely and intelligently. That means you're telling me that you fully understand what you're doing here today
yes, correct.
and voluntarily.
Yes,
Has your attorney represented you competently?
yes,
Has he answered all of your questions?
yes,
Has he looked at this matter thoroughly?
yes,
Has he discussed the discovery that the evidence in this case with you?
yes,
Has he discussed whether or not you have any defenses or perhaps a lack of defenses in this case?
Yes,
Are you satisfied with his services?
yes.
Do you have any questions for the court or for your attorney before we proceed?
Not at this moment, Your Honor.
All right. Okay. I'm sorry, I'm having an issue right now where my ears are both ringing and I can't, it's very difficult for me to talk. So it's very difficult for me to be able to go through this, but I'm going to try. So no one's made any threats or promises to you and you're satisfied with your attorney's services and you don't have any questions for the court. And that's what you're telling the court here today.
Correct, Your Honor.
Mr. Chapman, were you able to go over the facts alleged in the criminal complaint as well as the evidence with your client?
Yes, Your Honor, both before and then after I was reappointed, I again discussed it with her.
And did you go over how they would apply to the elements that the state would have to prove?
Yes, Your Honor.
Do you believe she's entering her plea freely and intelligently and voluntarily?
Yes, I believe she is.
And she's competent to do so?
She is.
And she understands the rights that she's giving up here today?
She does, Your Honor.
All right. You're pleading guilty to a felony. Do you understand that you would no longer be able to use or possess a firearm for life?
Yes,
No longer able to vote in any civil election until or any election until your civil rights are restored?
yes, Your Honor.
Do you have any questions, at least right now, before I begin and take your plea?
No, I do not, Your Honor.
All right, then as to count 1, OWI 5th, how do you wish to plead?
Guilty, Your Honor.
The court will find your plea is done freely, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to give up your rights. I'll find a factual basis to accept your plea of guilt. Based upon that, I'm going to find you guilty of OWI 5. Count 2 will be dismissed and read in. Count 3 will be dismissed and merged in with count 1. A judgment of conviction will be entered today. Before I go to arguments, Ms. Stady, you have somebody who would like to make a character statement on your behalf. Is that correct?
Correct, Your Honor.
All right. Her name is Jennifer Donaldson. Miss Donaldson, can you please tell me who you are, your relationship to Miss Stady, and what you would like me to know?
Thank you, Your Honor. My name is Jennifer Donaldson, and I am the owner of Empower Treatment Center in Rochester, Minnesota, also a woman in long-term recovery. I know Sarah through her significant other, Mike Benjamin, and we have been actively involved in this with her since going forward. We were the ones that did the chemical dependency assessment when she was in Olmsted County's custody. And once we do the assessment, we start with them recommendations, we start acting immediately to be able to help and provide whatever services that client needs. At that point, we reached out to a Minnesota Adult and Teen Challenge, which is a short-term program and eventually turns into a long-term program where it can be anywhere from 13 to 14 months long, where they basically are retraining your brain. We discussed it with her, Mr. Benjamin, and my husband as well, who's also in long-term recovery. And it would be a phenomenal program for her to kind of rebuild back her life, but also get some treatment to see what triggered her 10 years ago. And kind of work towards the goals of rebuilding the relationship with their children and having a successful life and being a benefit to the community. And being a stable citizen and figuring out what that problem is because obviously, as you're probably aware, and you see a lot of these cases, any kind of addict, it is a DSM-5. It is just like if you had diabetes or cancer. It is a disease. And that is one of the things why I left my corporate America job to get into this industry, is to help people like Sarah. I will tell you, there is very few people that I actually take time away to speak on their behalf in a court of law. When we realize there's 100% in on being able to come up with a solution and what they need to do and how they would need to change and live a full life for recovery, we're there 110%. Sarah has proven that to me and my husband, that that's what she wants. We've had many conversations while she's been in custody. I have essentially mentored her. I've worked with a lot of women on that over the past 16 plus years of my recovery journey. And I've worked with a lot of women. And, she's not BSing me on this. I can pretty much read that when someone is, when a client is, and when a client isn't. She's done a lot through her life. And what I'm struggling with, and I understand Minnesota and Wisconsin laws are different. What I'm struggling with is she was doing great for 10 years. Something triggered this. We need to find out what triggered it and what's going on with it. And I believe everyone also has to pay for their crime that they've done. And at the same point, what can we do to help prevent that? And yes, time served. I have 3 DUIs. I sat in jail. I sat in custody. But at the same point, sending someone away for 18 months when she's got 2 young children at home and a phenomenal support system, I don't think is going to help the recovery. I've seen both ways where incarceration has helped. I've seen where people have done the long-term teen challenge program where it's done an amazing thing. My husband is a graduate. And I'm a single mom too, and it breaks my heart to see what she's done. And I know that she has remorse for it. I know that she wants to better herself. I mean, she's talked to me about trying to figure out a way how to give back to the community with people in recovery. She's like, if I have to do this, Jen, that's fine. She goes, I'm going to better myself. I'm going to do what I need to do. And she goes, when I get out, if I can be back in the recovery community, she goes, can I come work for you? That spoke volumes to me, because I will tell you, getting in this industry, in this field, you have to have a heart and a passion and a soul for it, which I think she does. She wants to be able to tell her story. I think there's better ways of making more people realize that, going down this path isn't the right way. And it's just, Sarah has it in her. She has a fire in her to overcome this. And I would just like to be able to give her the opportunity to not spend as much time behind bars as what the 18-month mandatory. If I would plead with you to see how creative we can get with this and be able to do something, because I do believe she'd be a huge benefit to the community. Just the fact she wants to tell her story. A lot of people don't do that. A lot of addicts don't do that. And it just isn't right. And I'll be honest with you. I had a brother that died from a drunk driver. So it's hard for me to speak on behalf of people that drink and drive, but I did it myself. She does feel remorse. She knows what she could have done. And I've been pretty hard with her. And I don't know. If there's anything we can do to get creative with this, I know she would give back, and I know she would do such amazing things for the recovery community. And I'm sorry, with the epidemic that's going on with addiction, we need people like her telling her story that could potentially change someone else's life. I mean, if she touches one person, that's all that matters. It makes a huge difference. It really does.
Thank you, Ms. Donaldson. All right, now I'm going to turn to Mr. Schmidt for your argument and sentencing recommendation, please.
Sure. My recommendation is going to be 18 months initial confinement, 1 year extended supervision. So Ms. Stoddy has...
Simply 1 year?
Yes. Ms. Stoddy has a lot of unique characteristics to her that cuts positively and negatively. She doesn't appear to be a person who has much connection to Wisconsin. All of her convictions are in Minnesota. It's the 4 OWIs, it's 2 driving inimical to public safeties. So all of her convictions are driving related, 2 of them not necessarily alcohol related. Even in this case, when she had contact with law enforcement, she said to them, you know, I'm not from Wisconsin, my OWIs are in Minnesota. Miss Stottie's OWIs occurred, 2 of them in 2010, 1 in 2011, and then the last one in 2013. So they all appeared within a relatively close range, and the last one was 12 years ago. So she hasn't had an OWI in a very long time, which is why the reason I'm recommending a shorter term of ES than I normally would is because of that, and because she's not a Wisconsin resident. I think she's already done a lot of treatment in Minnesota as well. So I think a lot of what she'll be doing will be refresher, relearning things, repicking up techniques that she didn't apply here. The reason why I'm arguing for the 18 months initial confinement, I don't think the court should go higher because of that gap since the last OWI is so immense. The reason I'm arguing for the 18 months in this case, though, is it can be easy to forget why OWI is a crime and why it has such a high penalty. Because whenever we have an OWI where there's nobody who got hit or killed, we have just the offender. So all the information we're hearing is about rehabilitative potential. And that fixes the focus directly on what benefits them. OWI is a crime. It has such a high penalty because it's a high risk crime. It's a crime of risk. That's why the legislature always changes the reckless driving laws in tandem with the OWI laws, because they're both associated with risk. And it's kind of an oddity, I think, personally in Wisconsin, that if someone has an OWI 4 or an OWI 5 or 6, you know, we talk about like 1, 2, 3 years prison. When somebody has an OWI 5 or 6 and they hit someone, it goes way higher. If they hit someone and kill someone, it goes higher still, because the actual act is the same in all of those. It's the risk. In this case, the risk imposed was pretty high. There are certain blood alcohol concentrations where a person might be, am I intoxicated? Am I just a little buzzed? Am I good to drive? Miss Dottie was at a 0.269, which is well beyond that. She clearly knew she was intoxicated. You could tell from the statements to the officers. She was pretty hammered. She knew she shouldn't be driving. She mentioned saying, I'm getting arrested to an OWI before they even really arrested her yet on the phone to a significant other. I fully believe, based on what we've seen from her and what we've heard from the character witness, that she has the fire. She has the desire to change. My concern is with the follow through. That's why I think we need the prison and the ES, because we've even seen it just in this case with the missed court appearances. She's already forfeited more money in cash through non-appearances in this case than most people get as the fine for this offense. And I think that demonstrates, you know, the fear of seeing this to fruition. Being sober is scary for people who are alcoholics. And I think she needs that prison and that ES to deal with that. It's fully true that substance abuse, alcoholism is a DSM-5 disorder. OWI is not. Thank you.
Thank you. Before I begin and ask your counsel for argument and his sentencing recommendation, again, I apologize for having to stop. Do you understand? And I did ask you or tell you this and ask you this, if you understood that I don't have to follow any argument as to going lower than the mandatory minimum, but do you understand? I don't have to follow any recommendation. Nothing's binding on me. Do you understand that?
Yes, I do, Your Honor.
And do you still wish to proceed?
I do.
Okay, thank you. Mr. Chapman, argument and sentencing recommendation, but do you have account for her jail credit?
Yes, Your Honor. It is 78 days.
Okay, thank you.
I've got the dates if anyone wants them.
Thank you. And I'm bending over, just so you guys know, that to get my OWI information, because with OWI 5s, I have to specifically calculate the fines.
Oh, given that it's a prison sentence, they do not count today, so it would be 77 days, actually.
Thank you. Argument and sentencing recommendation, please, Mr. Chapman.
Judge, I think the state laid it out perfectly as to why this case calls for 18 months. And Ms. Donaldson addressed the rehabilitative potential. And I know that Ms. Stady is going to address the court and probably address her personal situations in more detail. Specifically, I'm asking the court to consider less than 18 months under a particular statute that actually doesn't call for the court to look at specifically the seriousness of the offense or the rehabilitative potential. I agree that under the seriousness of the offense and the rehabilitative potential, 18 months would be the appropriate sentence. I don't think it calls for more than that 18 months, but under the statute that calls for the exception, it asks the court to look at would the community benefit? So is it in the community's interest that Ms. Stady serve less than 18 months? And would the community be harmed by her serving less than 18 months? So I'm going to focus mostly on those particular two issues. First of all, as to whether the community would be harmed, I don't believe there would be any difference to the community as to whether Ms. Stady serves 18 months or 12 months or something in between. She's not going to be eligible for the earned release program in prison. She may be able to do some sort of treatment in the community, but really the prison is about punishment. That's what she's going away for. And I think the punishment aspect to Ms. Stady and whether she learns her lesson won't make a difference to the community, whether that's 18 or 12. I believe that the 12 would be sufficient, that she is sufficiently punished. As to whether it's in the community's interest, that's a different question. I call the court's attention to the fact that Ms. Stady is educated and well employed. She works as a project manager on building projects, building government buildings, essentially. So she's helped managing people in large projects. She's also not just dealing with this case, but she's also active in her church and volunteer work. She volunteers at Hope Lodge, which is a housing center at Mayo Clinic for cancer patients, and at Ronald McDonald's house doing food preparation. And she's also involved with the Adopt a Highway Fund and Litter Bit Better, which is another program that helps pick up the community, the streets around her. She has 2 children, which I believe the community would be served by having her out to see them. And specifically in reference to the state saying she missed court, not really an excuse, but I would point out that she gave birth to her more recent child in May of last year and then missed court, I believe, in July of last year. So not so much fear of sobriety as it was fear of leaving her 2-month-old newborn child. And there were no additional crimes that led to her coming into police contact. They just showed up at her door one day and said, "Hey, don't you have a warrant?" and brought her over to Wisconsin. I believe that once she gets out, piggybacking on what Ms. Donaldson said, she is a good candidate for treatment, and she will be addressing these concerns probably at Teen Challenge when she's eventually released. This case calls for prison, and she's going to go to prison. There is no creative way to avoid that, and I'm not asking that. But I'm just asking the court to recognize that Ms. Stady is a valuable member of the community. She does provide services to the community, both through her employment, her volunteer work, and her parenting duties. And that having her out in the community addressing these benefits to the community 6 months sooner, I believe, is a benefit to the community. If the court believes that the additional punishment is necessary or that it's an additional risk to the community to have her out earlier, then follow the 18th month recommendation, please. But if the court believes the community would benefit to have her out early, I'd ask the court to consider that.
All right, thank you. Ms. Stady, do you care to make a statement here today to let me know anything that you wish for me to know?
Yes, Your Honor.
Okay,
Yeah, you're okay. Go ahead.
you may begin.
All right, Your Honor. First of all, I would like to apologize to the court and to this community for my actions. I know that drinking and driving is wrong, and I should not have tried driving to my friend's cabin after participating in the polar plunge. Second, I've done things in the last 12 years that I regret and that I'm not proud of.
I'm sorry.
I'm sorry.
You're reading, and so
Okay.
I just need
Yes.
to
Yes.
to ask you to just read slower so my court reporter can take it down,
Okay.
because this is a prison sentence, and as a prison sentence, she must do a transcript, okay?
Okay.
So I want to hear everything
Okay.
from you.
Sorry. Okay. I'll restart.
Okay.
Your Honor, first of all, I would like to apologize to the court in this community for my actions. I know drinking and driving is wrong, and I should not have tried driving to my friend's cabin after participating in the polar plunge. Second, I have done things in the last 12 years that I regret and that I'm not proud of, like staying with my son's dad longer than I should have, leaving the architecture engineering firm I was working at to go to a general contractor. My biggest regret is being selfish and getting pulled over for an OWI and siren. I obviously was not thinking about how drinking and driving would affect my son at the time. And now my significant other and our 9-month-old daughter. Let alone if I were to hurt somebody else or myself, and I thank the Lord that never happened. I've also done things in the last 12 years that I am proud of, and that has made me into the person I am today. I have a wonderful family, and I'm so thankful for Mike Benjamin, who is not related to any of the Benjamins around here, no offense.
Please slow down.
Yes. Who is taking care of my 7-year-old son, Quinn, like Quinn is his own, and our 9-month-old daughter, Livy. We have become great friends with our pastor and his wife, who live 2 houses down. Quinn and their kids love playing together. We started going to Bible study on Thursdays with a group of women who are amazing this past summer. In 2020, I went back to college while working full-time and received my Bachelor of Science in Project Management in less than 2.5 years, testing out of 13 different classes. And at the end of 2020, I got my sole proprietorship for a commercial cleaning company, Reliable Clean Rochester, specializing only in post-construction cleans. I volunteer through work and on my own at multiple different organizations. Adopt a Highway, Ronald McDonald House, American Cancer Society, Hope Lodge, and I've participated in the polar plunge the last 3 years. I coached my son's t-ball team 2 out of the last 3 years. And I love volunteering for school field trips or events because I did not have that growing up. I've worked in the construction industry for almost 9 years and was a part of the interview process and team put together for the biggest Rochester Public School referendum in history and worked closely with the school district. I also have worked closely with Mayo Clinic construction managers since 2018 and worked on projects including the pharmacy addition, underground pedestrian and utility tunnel, Stevens 4th floor, and a 4-year project replacing 4 400,000-pound boilers in Franklin Heating Station. That will never happen again in this lifetime. I've also brought my son to a project every year for the last 3 years at the end of the school year so he can see how hard work pays off and see something getting built in real life. I do have a problem with drinking, and when I was in Rochester, I did a chemical dependency evaluation.
Again, I have to ask you to slow down.
All right.
Everybody does it.
Yeah.
Read slower than you think you should have to.
I did a chemical dependency evaluation recommending the long-term 13-month teen challenge program. I know Wisconsin has different laws than Minnesota, but this program would not only benefit me, but the community and my family. And I do have a copy of each of the evaluations in the acceptance letter. We all make mistakes and hopefully grow and learn from them. I was young, Your Honor, with no direction from either of my parents. People accept the science of the medical field, but do not accept the science behind the criminal justice system in which people do change. I had to learn things the hard way and by myself. This isn't a common thing anymore. And I have a good support system that I have back home. I don't want this to sound bad or for you to take this the wrong way, Judge Mogan. But if this law came into effect to send to prison 6 years ago, I wish we could look at what I've done in the last 6 years and not from the last 12 to 15 years. I do respect the court's decision and I'm ready to deal with the consequences from my actions. Know that God has a reason for everything, and maybe this is just a part of my story. Yes, Your Honor.
All right, thank you.
Thank you.
Ms. Stady, I do appreciate all that you have said. That was a very thought out and very thorough statement. And it did give me a good look into your life and your rehabilitation after this incident occurred and what you have been doing. In sentencing, a judge has to look at certain factors, certain things. I have to look at first the nature and the gravity of the offense. How serious is this matter? Then I have to look at your character. I have to look at your prior criminal record and other factors about you. And then I have to look at needing to protect the public. All right. But I also have other things that I have to focus on and look at. If there are any victims, whether or not you have rehabilitative needs, I have to look at any undesirable behavior patterns. How culpable are you, your age, your history. I also have to look at deterrence, okay? Not only specific deterrence, deterring you from committing crimes like this again, but general deterrence from having others see that this won't be allowed and permitted, okay? Deterrence.
Yes.
That's part of what my job is, not only to punish the individual in front of me, but to look and see if there are ways to rehabilitate, because that's the goal. The goal is to rehabilitate so that you won't commit further crimes, especially this type of crime, but also so others won't as well. Now, this is a very serious crime. No doubt about it. Very serious crime. OWI 5. And I believe it's a 0.269 OWI 5. Very serious crime. And my higher courts tell me that I'm to give no more confinement than is necessary to meet the general sentencing requirements and the factors. All right. So I have to look at all of the factors and determine what would be an appropriate sentence. I can't look at this and go, this is a maximum possible penalty. OW5s are serious and it's the maximum penalty that I'm going to sentence you to. I have to look at all of the things and weigh those factors. And that's essentially how a court comes up with a length of a sentence. Okay. And here it's a prison sentence. Again, we have you highly intoxicated, 0.269, which is highly intoxicated, operating a motor vehicle on a highway or roadway of a county, which could put not only yourself at danger and risk of injury or death, but it puts others at risk of injury or death. I don't know how many times I hear of accidents of people involved in OWI accidents that cause death. It's, I don't want to say daily, but around here, you hear it all the time, a lot of the time. And it's scary. It's extremely scary. And that's why this is a very serious matter. I heard the arguments from the state and I heard the arguments from your attorney, and I listened very carefully to Ms. Donaldson. Ms. Stady, from the very beginning, I'm going to tell you, the very beginning, you wanted to take responsibility and you wanted to be accountable. I'm going to tell you that from the very beginning, you did. And then we had, I'll just call it a hiccup, where I didn't know, because you didn't let me know, that you gave birth to a child and you didn't want to leave that child. I was in the dark. I'll tell you what came across my mind is that you changed your mind. You knew this was prison and you didn't want to go. And that's essentially what it was, but I didn't know, you were pregnant. I didn't know that you gave birth in May. All I knew is that you were evading responsibility. You were evading my case and essentially fleeing, not coming to court. And you had a significant amount of money posted, $4,000. That is a lot of money. And that's already been long gone forfeited. Can't get it back. It's gone. That money should have been enough to assure your appearance for court, because that's a lot of money. For a single mom who's raising 2 children, that's a lot of money. But it wasn't enough to assure your appearance. It wasn't enough for you to contact your attorney and let him know what's going on, or contact the court and let me know what was going on. It wasn't enough. And then I don't know how it came about that you are now in custody. I think your attorney said you were a law enforcement officer in your state, came and knew that you had a warrant in Burnett County. In Minnesota, they knew that you had a warrant here in Burnett County, Wisconsin, and they arrested you and brought you here. You didn't turn yourself in. And you're shaking your head up and down that that's not the case. You didn't turn yourself in. So again, to me, that's absconding. That's evading the responsibility. Once you were in custody, once you were back in custody, the Sarah Stady from the beginning came back. And you stated, again, I want to be responsible. I want to be accountable. I want to have my plea and sentencing. And you didn't even have your attorney at that time. You were prepared to even move forward without an attorney, because you were ready to be accountable for your actions when you were back in custody. That does tell a lot about your character. But again, you had to be in custody for that to occur. You have done a lot with your life in that amount of time, and you have done a lot for other lives in that amount of time since your OWI of March 4th, 2023. You have. I've heard it. You are a good person. You are a good mom. I have no doubt about that. And I'm going to tell you, I feel for you. I feel for you that you have been away from your babies for 77 days. I feel for you that you are going to prison. It's mandatory. I cannot, as a judge, this is not an emotional process. I cannot, as a judge, sentence somebody because I feel. I have to look at all of the factors and all of the things. And with all of the factors and all of the things, and even though you've done a lot in your life, I agree with Mr. Chapman. The community would definitely benefit if you were not in custody, because it sounds like you are building a really good relationship with a lot of people and a lot of entities where you can help a lot more people and you can continue to help yourself. I agree with that. And I would love to know, as well as Ms. Donaldson, that triggering event. What happened? Something happened. Something did. Maybe you are emotionally aware of what happened. Maybe you're not aware because it's pushed way down. I'm not certain, and I'm not going to make you tell me. So the community would definitely benefit from you out of custody. But I cannot find that the community won't be harmed, because I have to look at deterrence. And to me, that's very important. And here it's not necessarily directed completely at you to specifically deter you from committing this again, because I'm going to tell you, I think you've learned your lesson. You do not want to be away from your babies again. This is tearing your heart out. It is killing you. But I have to look at general deterrence. I have to look at the community. And if I do this once, then people will expect me to do it again. I'm not the legislature. I did not write the law. I did not determine that mandatory minimum, but it's there. And it's there for a reason, because these are serious. So as it relates to count one, the OWI 5, I'm going to sentence you to 1.5 years of incarceration and 1 year of extended supervision. And that is very low for extended supervision. I would have normally done 5 years, but I believe in the argument by the state, and I believe the statements made by Ms. Donaldson, and I believe your statements as well. And I think you're going to get your life back together. I think you're going to do the things that you need to do. And I don't think you need more than 1 year to do it. And I think, especially if you're going to look at Teen Challenge, which is an amazing program. It's an amazing program. If you're going to look at that, or you're going to look at other treatments, you're not going to need anything longer than 1 year. In my calculation of fines and fees, I come up with $4,412. That does include the $10 blood draw fee. So $4,412 total. The court has ordered that all of the costs and fees are to be collected as a percentage determined by the Department of Corrections to be reasonable while in state prison and as a condition of your extended supervision. The Department of Corrections shall collect these sums. They'll collect it from you. And at minimum, when you are released, at minimum, $100 a month. Okay?
Yes.
And that can be reviewed later. If I, well, and I'm going to tell you, here's the deal. Once you are released from prison, and if you come back to me, and Ms. Donaldson is hearing this, and you want to do community service, I will waive as much of that as I can. Okay? Which could be thousands of dollars. Because I believe that you will do that. I believe from hearing from Ms. Donaldson and hearing from you, you will do that, and you will put, because you already are. Okay? So Ms. Donaldson, please remember that. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose your right. You're pleading guilty to a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. If you fail to pay your fines and fees, not only will the court enter a civil judgment against you, but I will issue a warrant and you could sit up to 6 months in jail. You see how that goes. I need your DNA. The jail will make sure that they have it. I'm not certain if this is a charge that you can have your DNA expunged, but you can attempt to do so by a written letter to the Department of Justice, not to the court, to the Wisconsin Department of Justice. 77 days of jail credit. I believe I've covered everything, but am I missing something, Mr. Schmidt?
Not that I've noticed.
Mr. Chapman?
I think you have to make a finding of eligibility for earned release
Oh.
program and challenge incarceration. She's not eligible to be released early, and I'm guessing that they won't even put her in it because she can't get out early, but I'd ask the court to find her statutorily eligible.
I find her statutorily eligible on extended supervision only.
Oh, if revoked is what
If
you're saying?
revoked.
I see what you're saying.
Yes, if you're revoked off of probation, you would be eligible for the challenge incarceration program and the substance abuse program, but not while in prison because this is a mandatory minimum sentence, okay?
Yes.
All right. Thank you, Mr. Chapman, for reminding me about that. We are adjourned.
Thank you, Judge. I gotta get your signature out quick.
Okay, why is there a Juan Flores on this meeting?
Before we get the answer to that, ladies and gentlemen, I'm going to introduce you into our Kansas block. I'm not gonna say it's the necessarily the Greenwood County or the several different counties that this docket handles, because it's going to be a few different things. You're going to see Judge Ricky here for a few minutes. Then we're going to spend most of our time with one of my favorites, Judge Webster. Once Judge Webster's over, then we're moving on to Judge Simpson. And that's how we're going to close our day, ladies and gentlemen. We got about 45 minutes left in this side of the block. I'll see you on the other side.
There's no response.
Hi, Judge. I am Counselor Flores, and I am resident McLaughlin's counselor, and they have him here right now.
Okay, very good. Thank you.
Yep.
Jesse Travis McLaughlin.
Yeah.
This is State of Kansas versus Jesse Travis McLaughlin. It's case number 2024 CR 397. Mr. McLaughlin appears from a Hutchinson Correctional Facility Zoom location. Brett Sweeney appears for the state of Kansas. Mr. McLaughlin, I have before me a charge of battery against a law enforcement officer, a level 5 person felony. Since a felony is involved, we will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield. Judge Satterfield's next docket for that purpose would be April 7, 2025, 2:30 p.m. You must fully participate by Zoom in Judge Satterfield's docket at that time, April 7, 2:30 p.m. I trust, Mr. McLaughlin, that you, being in prison, don't have the financial resources to hire your own lawyer.
That's all right. I can represent myself.
Okay, well, you can take that request up with Judge Satterfield. At this point,
Every
in
man
an
must
abundance
speak
of
for
caution,
himself, Your
I will
Honor.
appoint a lawyer, and then you can, before Judge Satterfield, properly conduct a proceeding if you really do want to
Point of
represent.
order. What gives you jurisdiction to appoint a lawyer over me?
I have statutory authority to do so. So, Mr.
So
McLaughlin,
what
I'm
gives
going to
you
appoint a lawyer at this
what
point.
gives you jurisdiction over me? You must establish jurisprudence as a point of order.
I'm not going to play your sovereign citizen gibberish game.
I'm not a sovereign citizen, sir.
All
I'm not a
right.
sovereign citizen.
You sound like one.
Well, I'm not.
All right. I assure you I have jurisdiction. So we've got a court date set before Judge Satterfield. I'm going to appoint James Watts at this point to represent Mr. McLaughlin, noting he's made a request to represent himself. Again, that's to be a matter taken up fully before the assigned judge, Satterfield, at the hearing date on April 7 at 2:30 or some later time. And the court will set a $5,000 cash or professional surety bond, though obviously it's not going to affect his current incarcerated status. All right, bond set, attorney appointed, court date established on Judge Satterfield's calendar. Anything else we need to address at this time, Mr. Sweeney?
No, Your Honor.
Mr. McLaughlin? Apparently not.
Yeah, you need to address the point of order. As a
I've
first
addressed
point
all of
order
the
in
points
court
of order
the
that I'm
first
inclined
thing
to address
you must
today.
do is establish
Mr.
your
McLaughlin.
jurisdiction.
The McLaughlin matter is currently in recess, and we'll move on to another matter on the docket.
I object to moving on in any manner.
Objection noted and overruled, Mr. McLaughlin. All right, let's move
Request a
on.
copy
Okay,
of-
then.
I
Thank
request
you
a
to
copy
the
of the
Hutchinson
minutes,
Correctional Facility.
transcripts, these proceedings.
We can go ahead and take him off the meeting at this time.
All right, let's take up Estrada. He's here early for the 11 o'clock also, or he was. Did you? Nope. Mr. Estrada, you want to take up your case a little bit early?
Yes.
Okay, we are on the record in 2024 TR 617, State of Kansas versus Abel Estrada. Paul E. Dean for the state and Mr. Estrada appearing in person and pro se. The defendant was found guilty February 14th, 2025, ordered to pay scheduled fine in 108 within 15 days. And what have you done about that, sir?
I submitted the notice to appeal.
Okay. And have you done anything to perfect that appeal with the Kansas Court of Appeals?
I'm waiting. I literally just spoke to the court record, and they send it in, and the next thing is we're just waiting for the plea.
All right. First of all, I'm not making if Mr. McClendon has not withdrawn, I'm having him do so now because we do not, to my knowledge, pay for appeals of illegal tags. You'll need to be responsible for that yourself. And it's not enough just to file the notice that you intend to do it. You need to actually do it. So are you going to be representing yourself or hiring an attorney on that, Mr. Estrada?
I would like to get an attorney.
Well, you're going to have to hire one because throughout the trial, you kept insisting that if I'm remembering correctly, you didn't want an attorney. Isn't this one where I made Mr. McClendon stay on as kind of a backup counsel?
That's correct, Your Honor. He was essentially became standby counsel, and the court granted Mr. Estrada basically special consideration on this matter, as this is not even an offense that's eligible for court appointment, as it does not carry a sentence that exceeds 6 months.
Oh, yeah, yeah.
And I thought the court, well, maybe I was gonna double check the journal entry. I was thinking Mr. McClendon. Maybe even on the last journal entry had been allowed to withdraw, but there
Well,
was delay in me getting the paper, those journal entries to the county attorney's office because I had a few to complete after that day. So they had not all been emailed in. So I think that they might still be in the process of being e-filed because then the following week as I recall correct, I didn't travel to Greenwood County because of all the snow.
Okay.
I did my meeting with the commission via Zoom. So,
All right.
but today the court's ordering that Mr. McClendon is withdrawn. Mr.
Yes,
Abel
because he-
directed to, or advised he should perfect his appeal.
And I'm gonna set his pay or appear over 30 days to see if, and remember, you were to pay a $15 or $158 cash bond. Did you do that when you filed your notice of appeal?
I'm sorry, can you repeat that again?
I had ordered that if you appealed, you had to pay a $158 cash bond. Did you pay that appeal bond?
No, I didn't, but I was trying to get a waiver.
Well, I haven't seen anything about a waiver. Mr. Dean, have you seen anything about a waiver on his appeal bond?
No.
Well, I would deny any appeal bond. Mr. Abel, the facts in this case were very straightforward. You'd made up or bought a made up alleged tag that wasn't even close to being a legal tag. We spent a lot of money trying it, and I say a lot of money because I made the defense attorney stand by, even though you didn't want an attorney. Now you say you want an attorney to appeal it. Well, I'm sure not going to appoint one to appeal it. And if you cannot even afford your $158 appeal bond, I'm wondering how you're going to afford your attorney if you can even find one to take this kind of case on appeal. I would venture to suspect that it's never been done before, but if you think you can get it done, you're welcome to. But I am proceeding that until that appeal is perfected, you still owe $158 fines and costs, and you need that to pay that appeal bond. So I'm going to review this in 30 days, and you better have it all figured out, or you better have it all paid.
I actually started the process, and I send up the appeal notice, and I actually send I requested what's it called? The report. Oh, the journal entry from Mr. Dean office, but I haven't got it because the journal entry reflects $50, but I never got it. I never seen the charges or the journal entry. I'm trying to get all the information in.
That's all great, Mr. Estrada. The journal entry is being filed. Your Honor, I don't know that at least the state's not particularly interested in his steps to appeal. That's for him to figure out on his own. I do have one item to correct on the record, Your Honor. I think probably it's proper to note that Mr. Estrada was wanting counsel. However, both court-appointed counsels, Mr. Paul and Mr. McClendon, both believe that Mr. Estrada was also wanting them to violate their oath as an attorney and make arguments
that is incorrect.
Don't interrupt, please.
And make arguments in violation of both the U.S. and Kansas Constitution. Was the specific statement both the attorneys made to this court.
Yes. So,
that was all. I just wanted to correct it because he was asking for an attorney, even though, quite honestly, the case doesn't qualify for court appointment.
Oh, thank you for correcting the record.
Court still did grant him that an attorney, but the attorney's based. Mr. McClendon became standby because he believed that the arguments were not supported and were in violation of his oath.
All right, thank you. And it looks like from my docket notes, he was just ordered to pay 108 court costs. It says scheduled fine, but isn't this a misdemeanor?
I just asked for the basic fine. What I refer to as basic fine, it's not really a scheduled fine, but it was $50 because he did actually have it. He just
Okay.
refused to
Put on his car.
display it.
That's right. He refused to put it on his car, put on that cardboard.
So
Made
despite
up.
all the rigmaroles, I treated it just as any other case.
Okay. All right, Mr. Estrada, we're gonna make you come back for another pay or appear in 30 days. Missy, when is that?
March 28th at 11 o'clock.
All right, March 28th, 11 o'clock. We're gonna review this and see if you've paid your case and moved on, or if you're gonna keep fighting it and you never mind. All right, but I understand, Mr. Estrada, what is it you're appealing? The fine and court costs, or are you appealing the verdict?
I'm appealing the
Oh.
verdict.
Okay. And you want to maintain your argument that that cardboard tag was legal? The tag that you made was legal?
Yes. that is
Okay,
correct.
all right. I
Correct.
just wanted to make sure I knew what we were doing here. All right, I'll see you back here March 28th at 11 unless you paid your $158 balance. Thank you, sir.
Yeah, I just wanted to know, where do I get the report, the journal entry from Mr. Dean?
It'll be with the court, clerk of the court.
Clerk of the district court is the keeper of journal entries.
You mean the court record?
The court records are all through the clerk of the district court.
Okay, thank you.
They're the public record holder. Yes, sir. And that's about all I can advise you. I'm not going to help you practice your appeal. All right, we are in recess. You again are excused. And Mr. Paul, you can go, Mr. Estrada. Looks like Mr. Paul must be with another client right now. Will now be on the record in Vickery 2025 CR 11, State of Kansas versus Gavin Lane Vickery. The state appears by and through County Attorney Jill Gillette. Attorney William McClendon appears for the defendant Gavin Lane Vickery, who also appears in person and pro se. Mr. Vickery, can you hear me?
Yes, Your Honor.
How does your client wish to proceed on preliminary hearing, Mr. McClendon?
Your Honor, we'll be waiving pursuant to a plea deal.
Very well. Mr. Vickery, as you've heard throughout the afternoon, I have to go over some matters with you before I determine if you know what you're waiving and the consequences. You are charged with the felony in count 2 of aggravated battery, recklessly causing great bodily harm or disfigurement. A person charged with the felony has a right, as you've heard throughout the afternoon, to a preliminary hearing. At that preliminary hearing, the state of Kansas has the burden of producing evidence to make it appear that the felony crime has been committed and to show probable cause that you committed that crime. Preliminary hearing, however, is not a trial to determine whether you're guilty or not guilty. It is a hearing to determine if there is enough evidence to require you to stand trial, or in other words, to be bound over for trial. At a preliminary hearing, you have the right to be present with your attorney. You would have the opportunity to challenge the state's evidence, to challenge the existence of probable cause for further detention or for requiring bail. You would have the right to subpoena witnesses, cross-examine the state's witnesses, and present evidence on your own behalf. A preliminary hearing would also apprise you about the nature of the crimes charged and the sort of evidence you'd be required to meet if you were to stand trial. However, if you waive or give up your right to preliminary hearing, there will be no preliminary hearing, and you will be bound over to the district judge for further proceedings. You will be required to appear at a later date before the district judge for arraignment, at which time you will enter your plea to the felony charge as well as the misdemeanor charges against you. Until that time, you will continue to be obligated to appear under the terms of the bond. Have you talked to your attorney about waiving your right to preliminary hearing?
Yes, Your Honor.
Do you need any more time to visit with your attorney before we proceed?
No, I do not.
Do you want to waive your right to preliminary hearing?
Yes, Your Honor.
Are you voluntarily waiving this right?
Yes.
Has anyone made threats or promises to cause you to waive this right?
No, Your Honor.
Are you in good health today?
Yes, I am.
And are you taking any medication which might impair your judgment today?
No.
Mr. McClendon, do you know of any reason why the court should not accept the defendant's waiver?
No, Your Honor.
Ms. Gillette, does the state wish to waive its right to preliminary hearing?
The state does, Your Honor.
Very well, the court finds the state of Kansas has waived its right to a preliminary hearing. The court further finds that the defendant has made a knowing waiver of his right to a preliminary hearing after consultation with counsel. Therefore, it is the order of the court that the defendant is bound over to the district judge for further proceedings. The defendant shall next appear before the court for arraignment. Mr. McClendon?
Your Honor, this is a misdemeanor. Your Honor, this is a misdemeanor plea. Could we
right.
possibly?
So I will show that you waived your prelim, and then Ms. Gillette, there is some kind of offer to a misdemeanor.
Yes, Your Honor. If you want to keep it on one of your dockets, we could put it for one of the March plea dates.
Is there a reason we couldn't go ahead and do it, take up the plea now?
Jill, do you want his BIP assessment before or after he does this?
It doesn't matter to me. Judge, he's going to get a BIP assessment. We just wanted to have it available for the court and us at
Right,
sentence.
I typically order those as part of any probation. I think we can go ahead and take it up if you're all comfortable doing that.
I'm fine with
That's fine with me, Judge. I'm sure my client would be fine with getting this go.
Okay. All right, the terms of the agreement.
Your Honor, he sent a plea to count 1 and 3. I will be dismissing count 2 on behalf of the state. Part of the recommendations are going to be that he get a BIP assessment and follow through with any and all recommendations of his assessment, and continued no contact with the victim, no third party contact.
Now that might be a reason to set it over. Do you need to get any kind of notice to the victim that we're doing this?
I haven't heard back from her. Her victim impact statement went out February 4th. And so she hasn't written back yet. It's been 24 days. It takes.
Grace Vickery that's on the screen?
Yeah, it's me.
Yeah.
All right. So Miss Vickery, you've been following along with what's happening today?
Yes, my phone just died. I had to get on another phone, but I called yesterday to see if we could get the no contact order dropped because we have 2 kids together and it's been rough on me having the kids by myself, and I just needed, like, Gavin is a great dad, and I was just seeing if we could get that dropped so we could be able to parent and communicate about our kids so he could see them and everything.
Okay, well, we will address that perhaps later in the hearing, but at this time, do you want to be heard on the issue of the plea agreement? Do you want to talk to Ms. Gillette about it before we proceed?
I didn't even hear anything. I just
Okay, she
it.
has told me that she will dismiss the felony in count 2 aggravated battery. He has said he would enter a plea to count 1 domestic battery and count 3 criminal damage to property. Do you have any objection to that plea agreement or want to discuss what that means with Ms. Gillette?
Well, the destruction of property, I told the police that was his
Okay,
phone,
back up. Listen to my question.
Okay, yes, I
Do you
do.
object to the plea agreement or do you need to talk to
Yes.
Mr. Gillette?
Yeah, I object to it, yes.
All right, you want him to plead to the felony?
No. Just, okay, yeah, that's fine. It's just, it was his
Ms.
phone.
Gillette, do
that
you
he
want to,
broke.
excuse me, do you want to talk to her at all?
If you want to put us in a breakout room, I'll talk with her.
All right, and if it's better to put it over so you can have more time, that's fine too. Missy, would you please put Miss Vickery and Miss Gillette in the breakout room?
Judge, I do apologize. I have no idea why my service just keeps dropping random. It's been an oncurring theme with this new phone I got. It just cuts out middle of the hearing. I don't get it.
Well, I know you can't help that, so we'll just keep muddling through like we have to, and mine does it. My old computer system likes to do things like that. All right, we are back on the record in 2025 CR 11, State of Kansas versus Gavin Lane Vickery. All parties as before. We were joined by Grace Vickery, victim in the case, alleged. Ms. Gillette, are there any announcements? Thank you, Missy.
Yes, the agreement's going to be to count 1, and the state will be dismissing 2 and 3. The rest of the recommendations will remain the same.
All right, so Mr. Vickery, how do you plead to the sole count remaining of domestic battery?
Guilty.
Just a moment. Is anyone making you enter this plea of guilty today by any kind of threats or promises other than the plea bargain or plea agreement that we've been hearing about?
No, Your Honor.
Do you understand that even though you've gotten this benefit of the plea agreement, you still have a right to trial on that remaining count, and that if you continue with your plea, you're giving up your right to trial?
Yes.
And that you'll most likely be found guilty and you will not get this back,
Yes, Your Honor.
or you'll not be able to appeal the conviction.
Yes, Your Honor.
Okay. And in your own words, what did you do that makes you guilty of domestic battery?
I hit Grace.
And what's your relationship to Grace?
We're married.
When you were married at the time, when you hit her, did you hit her in an angry manner?
Yeah.
And this was January 30th of 2025?
Yes, Your Honor.
And where in Greenwood County, Kansas did it happen?
Fall River.
All right, I accept your plea as freely and voluntarily given with the factual basis, finding you guilty of count 1, domestic battery. I dismiss the remaining counts as part of your plea agreement by motion of state. And if you go over the recommendations again, Ms. Gillette.
Your Honor, it is a Class B person misdemeanor. We'll be recommending a 6-month underlying sentence. He's going to probably need at least 6 to 9 months to complete the BIP. So we'll be recommending 12 months of probation. When he completes BIP, then we would, if there's been no other issues, we would consider an early release if the probation officer requests it. All contact with Mrs. Vickery would be for the exchange of the children, and all contact would be to exchange children, child issues, anything that has to do with the kids.
Any fines?
I'm not asking for a fine because he'll have to be paying for the BIP courses, Your Honor.
Anything further, Mr. McClendon?
No, Your Honor.
Regular court costs, booking fee, probation fee.
Why are you gonna assess a bids fee, Judge?
How much do you have on attorney fees at this point, as this did say felony?
I don't know, Judge. It's probably gonna be around 3 to 350. If I had to guess, could be less.
All right. Where do you work, Mr. Vickery?
Nowhere at the moment.
Why?
I've been applying. I just had an interview last week, and I just got an email while we were on court about another interview.
How old are you?
22.
22, and you have 3 children?
2.
2 children? How old are they?
6 and 5 months. Well, it'd be 6, yeah, 5 months.
Does Mrs. Vickery work?
No, she does not.
So who's supporting the children?
Well, we get food stamps.
So the taxpayers of Kansas are supporting your children while neither of you work?
Yeah, I've been looking for a job.
When
It's
was the
just hard.
last time you worked?
December.
What'd you do up till then?
I've just been looking. There's not many options around Fall
Please.
River.
You have a driver's license?
I do.
Is it valid?
Yes, Your Honor.
Do you have a vehicle?
I do.
Is it legal?
Yes.
Tags, insurance?
Yes,
Do you have a high school diploma?
I do.
Do you have any work history?
Yeah, I do.
What is it?
I just worked at Textron Aviation. I worked at.
You work
I
at,
have
you
a
had
laundry
worked
list of
at
places.
Textron?
Yeah,
Well, that was a pretty good job, wasn't it?
yeah.
Why'd you lose that job?
They were asking me to move to the west side, and it was just a little bit of a too much
What's
of a
wrong
drive
with
for me.
that?
It's almost 2 hours away from me.
But if you moved to the west side, it wouldn't have been, right?
Well, I have a house here in Fall River.
You own it?
Yeah,
How much is it worth?
probably 120,000.
You have a house, $120,000. Is it paid for and clear?
Yeah,
But you've got a court-appointed attorney?
yeah,
So you've got the state taxpayers paying for your attorney, paying for your children, and you live in a paid-for $120,000 home in Fall River, Kansas,
yes, Your Honor.
and you don't work.
No, Your Honor.
You gave up a good job at Textron because you didn't want to relocate to the west side of Wichita.
Yes, Your Honor.
Do you see anything troubling about all of this?
A little bit, yeah.
Did you inherit the house? Is that how you got the house?
Not exactly. I mean, it was my parents' house, and I owned a house in El Dorado, and I had sold that house. Well, sold it and gave them the money, and they pretty much gave me this house.
How does a 20-year-old have houses paid for in full if he only works from time to time?
Well, I've had jobs since I was 16 or 17.
Okay, so a 16-year-old, 16 to 22-year-old has had enough jobs that he can buy a house, pay for it in full,
Yeah, it was only 30,000.
and now it's up to 120,000. You made a good investment.
Well, the El Dorado house was $30,000, and then I paid that off and sold it for 95.
And bought your parents 120,000.
Yeah, yeah. They built it, so I mean, if it was appraised, it'd probably appraised for around 120, but they put in probably 60,000 for it.
Are they still living?
Yes.
They just. There's something really wrong in your picture, sir, that you can just afford to give up a good job at Textron because you didn't want to relocate to Wichita. Do your children live with you?
They do not at the moment. They did before this incident.
Before you were charged with aggravated battery and domestic battery of their mother?
Yes, Your Honor.
So you can't find a job in Fall River, but you won't relocate to Wichita.
I was working in Wichita, but it was like very east, so it was about an hour. But they wanted to move me west, which would have been about an extra hour of a drive.
Unless you moved there. Okay, okay, we're not getting anywhere with this. I don't know, you seem to be one very fortunate individual. You got rid of a felony and a misdemeanor for one misdemeanor. You've got a you're 22, you don't have a job and have it for a while. And because you want to live in Fall River where there are no opportunities, but yet you own in full a $120,000 house, and you've got the state of Kansas paying for your attorney and your children. I don't know. My life sure didn't work that way when I was your age, but that's a different story for a different time. So here's what I'm going to order. Domestic battery is a B misdemeanor. The most I can order is 6 months, and I will do that. I'm not gonna, the statute reads that I am to give you a mandatory minimum 48 hours in jail and a $200 or $250 fine, unless you do the certified domestic violence offender evaluation, also called the Batters, the BIP, as Ms. Gillette was calling it, Batters Intervention Program Assessment. How much time have you served in jail from this case, for arrest or anything?
I think it was 6 days. I went in on the 30th and then got out on the 4th.
We lowered his bond on the 4th to 10,000 cash surety with no contact and no third party contact.
I don't know if all your fortune will run out at some point. You'll quit getting these benefits in life that a lot of people don't get, but from now on, you better do what you're told with at least the court. And what I'm telling you is you're going to get a 6-month sentence. You will get the 12 months the 12 months reporting probation that your attorneys agreed upon. And you are to call your probation officer immediately after this hearing. Are you ready to write down their number?
Yes, ma'am.
316-322-4153.
Okay.
You will be required to comply with all standard conditions of probation, which they will go over with you. You are within 14 days to contact someone who does a certified, has to be certified, domestic violence offenders assessment. And then if it recommends treatment or anything, you have to get started on that as right away. I don't want you dragging your feet on it. But you better have the appointment scheduled within 14 days. Provide proof to your probation officer. Sign any releases that your probation office needs to talk with the people doing your evaluation and treatment if needed. You are to have no contact with Grace Vickery except to exchange the children or converse about the children. Don't be playing games. Oh, we're going to go talk about the children for 2 minutes and then spend the rest of the time on a date for 2 hours. No contact, because until you get that evaluation, and have some idea of how dangerous you are, then it's gonna be limited. Now, have you seen the kids at all while you've been on probation
On bond?
or on bond?
One time, yes.
One time.
Yeah.
Well, I'm going to change my order. You're going to have no contact with Miss Vickery or the children until you have completed the evaluation and complied with it. Like I said, we need to know, this went from an aggravated battery whereby great bodily harm or disfigurement or death could have occurred. But if your evaluation thinks you're safe with your wife and children, then you follow that.
So if the evaluation says that I can be with my wife, then you're allowing it?
I'm going to allow the recommendations of the evaluation to control, subject to the probation officer.
Okay.
The probation officer has to feel safe with it too. And if I have to revisit that, we can have another hearing at a future date. Now, you are going to have to pay $100 to the Domestic Violence Offenders Fund, $350 towards your attorney fees, $100 towards the bids application fee, because this did start as a felony, $158 in court costs, $45 in booking fees, and $60 in supervision fee. And you're going to be ordered right now to start getting a job. You may just have to move somewhere where a job is available.
I think I should have one within a week.
In Fall River?
One's in Parsons and another one is in the east side of Wichita. They seem pretty promising, so.
All right, well, you make sure that you get a job as soon as possible and you keep a job.
Yes, Your Honor.
And I'll give you the same as what I customarily do. As far as payments, you can pay 1/12 of the total due each month. Your first 1/12 will be due in 30 days. That's March 28th. And then you'll have a 12th due on the 28th of each month thereafter. Is there anything else that I need to address that I haven't, counsel?
Are you going to allow him to be released after 6 months, Judge, if he complies?
No, I'm not guaranteeing that. I'll listen to a motion on it, but I'm not going to say, you do this, this, and this, and you're off of there. No, I'm not doing that. But if you have earned it, if you show me that you are safe to your family, to the community, to yourself, that you can maintain employment and support yourself and your children, then we'll talk about it. Anything else?
What about the third party no contacts? My grandma is on one of them and I help her a lot. I go up, she lives like right down the street, and she lives with her and her handicapped brother, and I just help her a lot around the house, and I haven't been able to because we have a no contact order.
Which one of the witnesses is she?
Bonnie Jones or Brenda Jones.
I have a
One of the
Brenda
two.
Jones.
Yes, Your Honor.
Miss Gillette, what do you have to say about that?
Which I believe it's his grandmother. He had her car when he left the house. So when he was driving or left, he was in her car. Her car's been, I think, returned to her. So I don't have any problem with him having contact with his
It
grandmother.
wasn't any threat physically or emotionally?
No.
Mentally? Okay.
It was solely driving her vehicle.
All right. She has to, if she is okay with that, she'll need to come forward and let your probation officer know that.
Okay, thank you, Your Honor.
Who's Grace Terrell?
That's Grace Vickery.
Oh, she goes by that too. And Amy Vickery?
That's my sister-in-law.
Was she in any danger during this, Miss Gillette? Amy Vickery or Megan Noland?
No, that's where the victim went and she was given clothing and a ride or loaned a car to town to come to the sheriff's office. So Amy's house is where she went after the incident.
Do we need to maintain no contact with those witnesses?
I don't believe so. She's married to Mr. Vicker, brother, from what I understand.
All right, well, don't you be any threat to any of them or it could jeopardize your probation.
I will not.
All right, I'm gonna let you go. Call your probation officer if there's nothing further then.
All right. Thank you, Your Honor.
You're welcome. We'll be in recess. All right, Mr. McClendon, is that your last one on the docket?
That is all I have for today, Judge.
All right, thank you, sir. You are excused.
$$J group.
All right, guys. This, ladies and gentlemen, is how we're winding down the afternoon. We got 10 minutes left in the show, but guys, it's going to be some of the more interesting 10 minutes that we've had. It's been a great show. Thank you for all being here. We'll talk to you later.
Group Holdings versus Azar Segdahi Safel. So, what was that?
Ready, Your Honor.
Good afternoon, Your Honor.
And where are we on this?
May I pass to the bailiff to hand this to the,
What is it?
this is the petition for joinder before federal court we filed, Your Honor.
The petition for joinder?
Yes. We amended the complaint and we added R&J Holding to our federal complaint in US court.
No. Have you seen that?
I have not, Your Honor.
Well, you can't just give me things and expect the court to take them without showing opposing counsel.
Okay, I have a copy for him. He refused to accept it.
Your Honor, she hasn't tendered it to me. Also, for what it's worth, yesterday at about 11 o'clock in the morning, the defendant served upon my office a ream of pleadings, responses, motions to stay, motions to dismiss, and so on. And I did my best.
For what case? For this one?
For this case. We're not a part of that federal case, and she is doing the classic attempting to turn this into a federal case, when in fact, it's just a summary proceedings action, Your Honor.
Absolutely not, sir.
And I did also give her copies of everything I filed by overnight mail and today. I handed it to her a while ago and she gave it back to me. I'm not going to fight over it, but they served me with a series of motions. I had to respond.
I don't have any motions.
No.
Yes, Your Honor, the package in front of you has a motion to dismiss, has petition for a stay, has answer to the complaint. and
Okay,
has a
you filed
counter
these
complaint.
today? Yeah.
No,
today.
we filed it yesterday, Your Honor. You only gave us a week to answer. Remember, Your Honor?
Your Honor, you gave her.
Oh, ma'am, I remember everything I do. Do not try to address me that way. I will have a memory that will throw you in circles. So don't come at me like that. Because if you come at me like that, you're going to get hurt.
I respect.
Counsel, what were you saying?
Your Honor, I was saying that as I recall, and I wouldn't challenge your memory, you may as well, when we were appeared and she asked for the opportunity to present some reference to this federal case, you said we're going to adjourn this till next Friday at 3, and you can deliver to me a copy of that federal case so that I can look at it, not file a whole host of other pleadings and other matters at the last minute. I mean, that was tough for me to handle, but I got it out, Judge.
Well,
A copy of federal pleadings is part of that package that was hand delivered to this gentleman and to the court, Your Honor.
We have nothing to do with that federal case, Your Honor, at this point.
No,
She
you
has a
do.
case against Wells Fargo, who was a prior mortgagee in the case. We have nothing to do with it whatsoever. We're the deed holder of the property.
there's also been a parties added.
They counterclaimed against us yesterday at 11 o'clock in the morning and filed several motions. No parties have been added to this case, but she says she wants to add us to that federal case, and I
Well,
encourage.
the caption is changed.
Correct.
Can't just change the caption.
Well, we haven't been served. And I got the doc.
Counsel, I get it. I'm just saying, this caption that I have on your documents is not the caption of this case.
I'm sorry.
The caption here, who is Carl Stafford?
Carl Stafford is here. He's my.
I don't care if he's here. He wasn't a party to this case, was he?
No.
It says all residents of the house, and he's the resident of the house.
You can't just change the caption.
What do you suggest I do, Your Honor?
You don't want to hear that. I suggest maybe you get an attorney, because I just don't.
She is an attorney, Your Honor.
Well, that's even more alarming. I don't even know what to do with this, because the caption has changed, right?
Yes.
You served motions, and apparently there's a counter complaint that the other side, or whoever was supposed to add, doesn't have an opportunity to answer. I don't even know if there's been a summons issued for these other parties.
Yes, there has.
Are you an attorney?
I'm not a bar license holder attorney. I went to law school.
Counsel, you filed an amended complaint, correct?
I did, Your Honor.
All right.
We have not received that.
I gave it to her.
No, we have not received, sir.
I gave you the packet and you gave it back. to me.
When was that, sir?
Just now, I gave it to
You
your
gave
husband.
it to
You
me
two
now.
want to have your own darn conversation. You can do it outside. You don't need me here.
I
I'm not going to be a third wheel on a date in my courtroom.
I'm sorry, Your Honor, very sorry. I did give her all of those pleadings and the amended complaint in a white envelope, which she
Did he-
handed back.
Did he give you an envelope and then you give it back?
Yes, because
Why?
because I tried to give him the joinder and he gave it back.
She never handed it
This is
anything
like,
to me.
this is like kindergarten. I'm going to accept the first amended complaint, counsel. You can serve it on her in whatever way you wish, in terms of either you can do it by email or you can serve it by first class mail. If she won't take it, she won't take it. What you filed, which starts out entitled Plaintiff's Defendants Answer to the Counter, you're gonna have to refile this. I'm striking this pleading. You can't just change a caption. Well, guess we're done. And so I'll give you a week to get that out. I realize it delays the proceedings, but I don't think I can do anything else, because I don't know why these parties are running around in this case that you just added to this as the petition to stay is filed on this is crazy. You're gonna have to start over. I'm striking all of that you
Okay.
filed, and you're gonna have to just do it right. I'll take yours, you serve it, they'll have to answer, and then we'll go from there. I don't know that putting it out to next week is gonna do us any good, so I'm gonna put it out to the 14th.
Thank you, Ron. I would ask the court if it may. She hasn't paid rent. They haven't paid rent since November. The rent for November, December, and January is $5,000 a month. And the rent for February and March is $5,500 a month. I would ask that you ask them to escrow.
What is the current monthly amount of rent?
It's, there's a holdover provision, but we'll accept the normal rent, Your Honor.
About 5,000?
5,000 for.
I'm gonna order escrow.
Escrow, we would pay it in escrow, Your Honor, but not to them, because they have to sell the property to us.
I'm gonna order that you pay escrow to the court in the amount of $5,000. I'm not gonna do a proration back to the original. You'll start that March 1st. It needs to be paid within 7 days of the date of my order, and then needs to be paid each month while this matter is pending. Do you understand that?
Yes, Your Honor.
Please
Thank you, Your
prepare an
Honor.
Order to that effect. I will
So
adjourn this.
February rent and March rent?
I can only have March rent.
March.
March.
I could prorate a day February, but I'm
That's
not.
not necessary. We'll accept the.
March 14, 2025 at 1 p.m. I feel a cold coming. 1 p.m.
You're on. Have a nice weekend.
Yeah, I will now. All right, now give it. Yeah, give it, because, Ann,
Can I take it?
can you what?
Could we submit the joinder or no?
You may, if it is in proper form, submit it anything that you like, but not to me.
Okay,
You can file it with the clerk's office once the file gets up there.
by all means.
Just don't. Just don't. Just
Are we dismissed, Your Honor?
bye. Yes.
Thanks, Judge.
Well, as Judge Simpson says, ladies and gentlemen, bye. That was such a good one. Ladies and gentlemen, I just thought we'd have to end one on a very light note after those crazy first set of hearings. If you did come in late, please be kind and rewind. It was a great show. And make sure you keep chat on, because chat has been wonderful through the whole show. I do appreciate everybody coming out. It's been a wonderful show. Don't forget, I'm putting out videos all day, every day of the week. Just come back, check up on me, and come back on the weeknights around, I don't know, 8 p.m. Central Standard Time, 9 p.m. Eastern Time. We'll be doing a live docket call from either Judge Fleischer or Judge Simpson or somebody like that. We'll be doing it live. Well, we'll be doing it premiere. Not quite live. Ladies and gentlemen, I'm your Lone Wolf Usul. I'm your host for these here proceedings. And I am your curator for the court gallery. Ladies and gentlemen, it's been a great Saturday morning and afternoon start. Y'all have a great Saturday, a great weekend. We'll see you next time. Same Wolf time, same Wolf channel. I'm Wolf. I'm out.